Folder in my lap felt heavier than it should have. Just paper. Just copies of documents I'd already read 100 times. But sitting in that hallway outside courtroom 4B, with the fluorescent lights humming above me and my heels pressed flat against the cold tile floor, it felt like I was holding something that could either save everything or destroy what little was left. I wasn't supposed to be there. That's the part nobody would believe if I told them. I wasn't a plaintiff, I wasn't a defendant, I wasn't even on the witness list, at least not yet. I was there because my mother had called me the night before, voice low and careful the way she always got when she was scared, but didn't want to admit it, and said, "Tessa, please, just come, just sit there, so I know someone is on my side." So I came. Before I tell you what happened when those courtroom doors finally opened, I want to ask you something. Where are you watching this from? What time is it where you are? Drop it in the comments. I read every single one, and honestly, knowing people are out there listening to this is the only reason I can talk about it without falling apart. Okay, let me start at the beginning. The real beginning. My brother's name is Roland. He is 41 years old, he has a law degree from Georgetown, and for as long as I can remember, he has been the person our family built their world around. Not because he demanded it exactly. It was subtler than that. It was the way my father's voice changed when Roland walked into a room, lighter, prouder, like Roland's presence confirmed something my father needed confirmed. It was the way my mother would pre-clear her opinions with Roland before sharing them at dinner, just to avoid the quiet disappointment on his face if she said something he disagreed with. I was 27 when my father died. Roland was 38. My father had built a small but real thing, a regional HVAC and commercial construction company he'd started out of our garage when I was 4 years old. By the time he passed, it had a staff of 62, contracts across 3 counties, and assets that the estate attorney valued, conservatively, at just under $4 million. Not generational wealth by any stretch, but real. Enough to matter. He told me, looked me in the eye over coffee at his kitchen table about 8 months before his diagnosis, that he was splitting everything evenly, down the middle. Half for Roland, half for me. He said he was proud of us both. He said he was proud of us both. He said he wanted us to carry it forward together. He died 11 months later. Fast, the way pancreatic cancer tends to be, and when the will was read, my name wasn't in it. I want you to sit with that for a second, because I had to. I sat in that attorney's conference room with Roland across the table and my mother beside me, and I listened to a document that my father had supposedly signed, describe me as, and I'm quoting here, a beneficiary of my personal love and guidance, which represents the truest inheritance I can offer. Everything else, the company, the property, the accounts, went to Roland. Sole discretion, no conditions. My mother gripped my hand under the table. She didn't say anything. Roland didn't look at me. He looked at the table, which I've thought about many times since. He knew what he'd done. I didn't fall apart in that room. I've thought about that too. I think I was in shock, honestly. I drove home, I sat in my apartment, and I stared at the wall for about 3 hours. Then I called the estate attorney and asked for a copy of the will. It took me 2 weeks to find what was wrong with it. I'm not an attorney. I'm a paralegal. I had been working for a family law firm in the area for 4 years at that point, which meant I knew just enough to know that something about the signature page felt off, the notarization date, the witness signatures. My father had used the same estate attorney for over a decade, a man I'd met at every holiday dinner since I was a teenager, and his notary stamp on the document was dated 6 days before my father was admitted to the ICU for the last time, which would have been fine. Except I had my father's hospital intake paperwork, and I had a phone photo of us together, one my mother had taken and texted me, from that same week. He was in a bed. He had a BiPAP mask on his face. He was not, as the signature page implied, sitting in an attorney's office signing documents in front of witnesses. I brought this to my mother. She cried for a long time. Then she said, "I knew something wasn't right. I knew it. We found a different attorney, filed a contest, and that is how, 14 months after my father's funeral, I ended up sitting in a hallway outside courtroom 4B with a folder of copied documents in my lap and my mother's voice still in my ear from the night before. She had called the moment Roland's attorney filed the motion to dismiss. "They're saying it'll be thrown out before it even goes to trial, Tessa. They're saying we don't have enough. We had plenty. We had the hospital records. We had a forensic document examiner who'd been retained at significant personal cost. I'd put it on a credit card, who had found measurable inconsistencies in the ink composition of my father's signature compared to verified samples. We had a timeline. What we didn't have was a judge who was going to give us the hearing we deserved instead of clearing the docket by the fastest means available. Our attorney had warned me about this. Will contests are hard, he'd said. Even with evidence, judges don't like them. They take time. They upset families. You need to walk in there prepared for the possibility that the bar they set for us is higher than it should be. I understood that. I just didn't know yet what else was walking into that courtroom. The doors opened at 9:02 a.m. I'd expected to sit in the gallery. That was the plan. My mother and her attorney at the plaintiff's table, Roland and his at the defense side, me in the benches like a spectator at someone else's life. But Roland's attorney, a smooth-faced man in an expensive suit whose name I will not use here, made a motion almost immediately after proceedings began. He argued that my presence as a potential witness was prejudicial to the proceedings and that I should be excluded from the courtroom until and unless I was called to testify. Our attorney objected. The argument went back and forth. I sat in the gallery with my hands folded in my lap, looking straight ahead the way my grandmother taught me. If someone is trying to rattle you, give them nothing, Tessa, not even your eyes. And then the judge spoke, and I stopped breathing. I knew that voice. Not the way you know a stranger's voice, but the way you know a song you haven't heard in years. It hits somewhere before your brain processes it, some older, deeper place. I looked up slowly, the way you do when you already know what you're going to see, and part of you is trying to delay it. The judge was a woman, mid-50s. Silver hair pulled back, reading glasses on a chain around her neck. The particular kind of stillness that comes from decades of practice in not showing reaction. Her nameplate, which I could just barely read from the second row, said the Honorable Deborah Kwan. I knew her as the woman who had mentored me for 2 years at my first paralegal position. The woman who had written my recommendation letter for the job I currently held. The woman who had, on the occasion of my very first deposition summary, called me into her office and told me I had an unusually sharp instinct for what mattered in a document. She'd been a partner at a civil litigation firm before she took the bench. I'd worked for her from age 22 to 24 before she was appointed. She didn't know this case involved me. There's no way she could have. My last name is different from my mother's remarried name, which is on the filing, and I wasn't listed anywhere in the original petition. She was reading the motion in front of her, expression neutral, and I watched her process it the way I'd watched her process difficult briefs all those years ago. Methodical, unhurried, thorough. Roland's attorney was mid-argument when she looked up and saw me. Just for a second. Maybe less. Her expression didn't change, but her eyes did something I recognized. A small recalibration. The kind she always made when a new piece of information arrived that changed her read on something. She did not recuse herself. I want to be clear about this because people always ask. A judge is not required to recuse themselves simply because they have a prior professional relationship with someone in the gallery. I had no party status in the case, and she did not know yet what my connection to it was. What she did was proceed with scrupulous, almost pointed fairness. Roland's motion to exclude me was denied. Our attorney's request to enter the forensic document analysis into evidence was granted. The motion to dismiss was, over Roland's attorney's sustained objections, denied. And then our attorney called me to the stand. I will not pretend I wasn't scared. I had testified before in a minor capacity as a paralegal presenting document summaries. This was different. Roland was 15 feet away from me, and he was looking at me in a way he'd never quite looked at me before. Not the dismissive inattention I was used to, but something more focused and considerably colder. Our attorney walked me through the timeline. The coffee table conversation with my father. The notarization date? The hospital intake? The photograph? The discrepancies in the signature ink? I answered every question clearly and completely, the way I'd been trained to, the way she had trained me. Then Roland's attorney stood up. He was good. I'll give him that. He started by establishing my professional interest. I was a paralegal. Didn't I stand to benefit professionally from the validity of my analysis? He questioned my relationship with my father, suggested we had been estranged in the years before his death, implied that my claim of a kitchen table conversation was unprovable and convenient. He found a narrow window in the hospital records where there was technically no documented reason my father couldn't have left the facility briefly. He made it sound reasonable, almost inevitable, that I had misread everything. He made me feel, for about 4 minutes, like I was the one who had done something wrong. I kept my face still. I looked at him directly. I answered every question. And then he made a mistake. He asked me whether I had any professional experience reviewing contested estate documents, attempting to establish that I built my argument on amateur analysis. And I told him yes, I did, that I had spent 2 years working for a firm that handled civil and estate litigation, doing exactly this kind of document review. He pushed, "What firm?" And I told him. There was a pause. He recovered quickly, the way attorneys do. But I saw him glance toward the bench. The judge had not moved, but she was very still in the particular way that meant she was paying close attention. He wrapped up his cross shortly after. Our attorney did a brief redirect, and then something happened that I did not expect and could not have planned for. The judge asked me a question directly. This is unusual. Judges can do it, but most prefer to let the attorneys drive examination. She looked at me over her reading glasses and asked me, in a very calm voice, how I had identified the specific discrepancy in the notarization date. What led me to look there first? I told her the truth, that I'd read enough contested estate filings to know that signature pages are where alterations most commonly occur when a document has been tampered with after the fact. That the notarization was the first thing I checked because it was the easiest element to falsify without touching the body of the document. That I'd noticed the date and then cross-referenced it because that's what I'd been taught to do years ago by someone who told me that a document always tells you where to look if you're willing to read it carefully. I caught myself. She noticed. Just a small thing. But she looked at me for a moment longer than the question required. We broke for lunch at 12:30. I was in the hallway outside, sitting on a bench eating a granola bar I didn't taste, when the bailiff came out and said the judge wanted to speak with both attorneys in chambers before the afternoon session. My mother grabbed my arm. "What does that mean?" I told her I didn't know, which was mostly true. What I suspected, but couldn't say out loud yet, was that the judge had identified what I'd almost said, the connection between us, and was being scrupulously careful about how the rest of the proceeding was structured as a result. The afternoon session was different. Roland's attorney seemed diminished somehow, like someone had quietly rearranged the furniture in a room and he couldn't identify exactly what had moved. Our attorney looked focused in the particular way that meant something had shifted in his favor. The judge was thorough in a way that felt almost surgical. She went through the forensic examiner's affidavit line by line. She asked Roland's attorney to address specific points in the timeline. She requested the original attorney's records, not copies, originals. Regarding the notarization session, she gave Roland's side ample, genuinely fair opportunity to respond to every piece of evidence. By 4:15, Roland had stopped looking at me altogether. I watched my brother across that courtroom for most of the afternoon. I've thought about this since, what it means to grow up next to someone, to share parents and holidays and the particular shorthand of a shared childhood, and then to sit in a room and understand fully what they chose to do. He didn't look evil. He never does. He looked like a man who had made a calculation and was only now confronting the possibility that he'd calculated wrong. He had an entire department of explanation for himself, I'm sure. He'd run the company with our father for years while I'd gone off to build my own life. He'd been the one present for the hard years. He'd earned it. Possibly he'd convinced himself somewhere along the way that what he'd done was a correction rather than a theft. I can't get inside his head. I've stopped trying. What I can tell you is what the judge said before she adjourned. She did not rule that day. Will contest cases of this complexity rarely resolve in a single session, and a full ruling would come later. But she denied the motion to dismiss with prejudice. She ordered the original notarization records produced within 10 business days. She flagged the forensic analysis for further review by a court-appointed examiner, and she stated in the particular language judges use when they are being precise about what they're saying and precise about what they're not saying, that the evidence presented raised questions material to the validity of the document that warranted full examination. Roland's attorney requested a brief recess before adjournment. The judge granted it. I watched Roland lean across the table and say something to his attorney, and I watched his attorney's expression when he responded, and I understood what was happening before my attorney came to find me at the back of the gallery. He wants to talk, my attorney said. Settlement conversation. Before this goes further. I looked at my mother. She had her hands pressed together in her lap, and she was looking at me the way she looked at me when I was 7, and had told her, very seriously, that I was going to fix the broken lamp by myself. Like she was terrified and maybe also a little proud. "What do you think?" she asked me. I thought about my father at his kitchen table, the coffee mug, the way he said down the middle like it was simple because to him it was. I thought about 14 months of credit card debt and document review and nights I didn't sleep. I thought about my brother's face when he didn't look at me in the attorney's office the day the will was read, and how I'd known in that moment, even without understanding yet why I knew it, that something was wrong. I want to be clear about something else. A settlement is not justice. I know that. The people who've been in this situation, and some of you watching this have been, I can tell from the comments on other videos, you know that a check doesn't restore what was taken. It doesn't mean the person who did it understands what they did. It doesn't put your father back at his kitchen table with his coffee, but it was real accountability, not symbolic, not a slap on the wrist. Roland agreed to a restructured arrangement that reflected what my father had actually told me at that table. The company was appraised. The distribution was recalculated. The process took another 4 months, and there were days during those 4 months that were genuinely terrible. There were conversations with Roland, required, logistical, awful, where we sat across from each other with attorneys present and said only what the attorneys told us to say and looked at each other like strangers who had once known the same person. The original estate attorney resigned from practice before the court-appointed examiner finished his review. I don't know exactly what that means. I have my theories. Here is what I know for certain. I know that my father meant what he said to me at that table. I know it because I knew him, and I know what his face looked like when he was being honest versus when he was being careful, and at that table he was being honest. The document Roland's attorney produced was not my father's real will. Maybe someday Roland will find a way to say that out loud to me. Maybe he won't. I stopped waiting for it either way. I know that I almost didn't contest it. The first attorney I called told me will contests were expensive, emotionally depleting, and statistically unlikely to succeed. He wasn't wrong about any of that. I almost let it go. I spent 3 weeks trying to talk myself into letting it go. And then I looked at the signature one more time. And I remembered something my mentor used to say when a junior associate wanted to dismiss a document because it looked clean on the surface. "Read it again," she'd say. "Documents don't lie. People do. But the document always tells you where to look." I read it again. Outside courtroom 4B, after the adjournment, the hallway was emptying out. Attorneys gathering papers, the bailiff locking up, my mother talking quietly on the phone in the corner. I sat back down on the bench where I'd started the day, folder still in my lap, and I just stayed there for a minute. Not because I was upset, just because I needed to feel the stillness before I stood up and walked back into my actual life. The judge passed through the hallway on her way back to her chambers. She slowed when she saw me. She didn't stop. It would have been inappropriate, and she knew it, and so did I. But she looked at me in the way she used to when I'd handed her a summary that was right. Really right, and I'd known it before she said anything because of the way she looked. She kept walking. I picked up my folder and stood up. There are people in your family who will take from you because they've decided that what they want is more important than what's true. And there are people in your life, if you're lucky, if you've worked for them and learned from them, who taught you how to read carefully, how to look where others skip, how to stay in the chair when someone is trying to rattle you. I was lucky. In multiple directions, on one particular Thursday, I was very lucky, but I'd also done the work. I need to say that too. Luck didn't find the notarization date. I did. And 14 months of not letting go, not because I was certain I'd win, but because I was certain something was wrong. That wasn't luck either. My mother flew home to Phoenix 2 days later. At the airport, she held my face in both hands the way she hasn't done since I was a child, and she said, "Your father would be so proud." I didn't say anything back because there wasn't anything to say that was big enough. I just hugged her for a long time in the departures drop-off lane while cars honked around us, and it was absolutely fine. That folder is still in my apartment. I keep it in a drawer now instead of on the desk where it lived for 14 months. I don't need to look at it anymore. But I don't throw things away that matter. If any part of the story sounds familiar, if you're sitting somewhere right now in your own hallway outside your own courtroom, real or metaphorical, I want you to know it's worth reading the document one more time. It's worth making the call. It's worth sitting in the chair. You know when something is wrong. Trust that. I've spent a lot of time since that Thursday trying to figure out what the real lesson was. Not the queen version, not the tidy thing you say when someone asks how it all turned out. The actual lesson, the one that lives underneath the outcome. Here's what I keep coming back to. Roland didn't become someone who could do what he did overnight. That's the part that used to keep me up at night more than the forged signature ever did. He built toward it slowly, in the same way people build toward most of the worst things they do. One small justification at a time, one quiet convincing of himself that he deserved more, that his contribution was larger, that the math of fairness somehow came out differently when he was the one doing the calculation. I think he believed it by the end. That's what makes it sad, honestly, more than it makes it monstrous. He chose his story over the truth so many times that the story became the only thing he could see. I'm not saying that to let him off the hook. What he did had real consequences for real people. For my mother, who spent 14 months watching her grief get tangled up in a legal fight she never asked for. And for me, who learned what it feels like to be erased from something your own father built with his hands. There are costs to what Roland did that no settlement recalculates. I want to be honest about that. But I also think about what I chose, in the small moments that didn't feel like choices at the time. I chose to read the document one more time when everything in me was tired and wanted to stop. I chose to make the call when the first attorney told me the odds were bad. I chose to sit in that chair on the witness stand and keep my face still when Roland's attorney was trying to rewrite the story in real time. None of those felt heroic. They felt like the next thing, and then the next thing, and then the next thing after that. That's what I'd tell anyone in the similar situation. Not that you'll win, because I can't promise that, but that the small choices accumulate. The discipline of continuing when continuing is hard. The intellectual honesty of looking at what's actually in front of you instead of what you wish were there. The ethical stubbornness of refusing to let someone else's version of events become the official record. Those things matter. Even when they're invisible, even when no one is watching you make them. Deborah taught me to read documents carefully. She didn't know, when she said it, that I would one day use that skill to save something my father left me. She was just doing what good mentors do, passing on precision like it was the most natural thing in the world, because to her it was. I think about that a lot. How the things people teach us echo forward into situations they couldn't have anticipated. How the investments someone makes in your mind can show up, years later, in a hallway outside a courtroom you never expected to be sitting in. There are people in your life right now who are teaching you something you don't know yet that you'll need. Pay attention. The knowledge won't always arrive labeled. And if someone has taken something from you, if you're sitting somewhere right now, certain that something is wrong even though you can't yet fully prove it, trust that certainty. Not blindly. Do the work. Read it again. But trust that the thing you feel when something doesn't add up is usually your intelligence trying to tell you something your emotions haven't caught up to yet. That folder is in my drawer now. I don't need to look at it anymore. But I remember every page.